let's discuss the different types of IP protection available for your startup business. First is patent. It protects inventions and innovations, and a patent grants exclusive right to make, use, and sell the invention for a limited period. Next is a trademark. Trademarks safeguards brand names, logos, and symbols. They protect against unauthorized use in the marketplace to ensure that your brand recognition is established in the marketplace. You can also have trade secrets, and they guard confidential business information. For example, your internal operation details or your vendor list, your customer list. It offers protection without the public disclosure as long as the secrecy is maintained. And because of that, it can be the cheapest form of intellectual property. And then we also have copyrights. Copyrights protect original creative works such as literature, music, and art. For example, your website is protected under the copyright system, and your promotional videos are also protected under the copyright system. So the copyright system provides exclusive right to reproduce, distribute, and display the work. And understanding and leveraging these different types of IP can be crucial for individuals and businesses to safeguard their intellectual assets and foster innovation. Remember, these are not individual rights, and you can bundle them and cross-mix them. So for example, your software invention may have copyrightable aspects as well as trade secret aspects. So, and what are potential trade secrets in the software? Let's say in the data and how you train your AI system. That could be a type of trade secret. The website design is obviously covered under the copyright system. The methods and the processes underlying how the magic of your product could be protected under the patent systems, and then your branding for your product is protected under trademarks. So that's an example of how different rights can overlap and create a mesh network of protection for your business. Now let's talk about why startups need patent system. Startups benefit from obtaining patents for several reasons. First, protecting their innovations. Patents provide the legal protection for the unique technologies for innovations developed by your startup. This exclusivity can be crucial for maintaining a competitive edge, particularly in these days where your go-to-market strategies can be copied instantly by your competitors. Next, patents can be used to attract investors. Patents can enhance a startup's attractiveness to investors because it potentially offers exclusivity. Investors often view patents as a tangible asset that demonstrates a commitment to innovation and differentiation in the marketplace. Of course, next let's talk about market differentiation. Patented technologies or products can set a startup apart from its competitors, helping establish a unique selling proposition and gaining a foothold in the market. The patents can deter your competitors from copying your go-to-market strategy. Patents offer licensing opportunities. So startups can generate revenues by licensing their patent technologies if they want. This is at your control, but if for some reason you want to establish your product as a standard in the marketplace, you may want to license your competitors to build the same product. And this can increase your market size, and it can also be a significant source of income and a way to expand the reach of your inventive work. Patents obviously can be used as a defensive strategy. As discussed before, patents can act as a defensive mechanism, deterring competitors from infringing on your IP. This can help avoid costly legal battles and protect your market share. Patents also offer negotiating power. Holding patents can strengthen a startup's position in negotiations, partnerships, or collaborations. It provides leverage when discussing terms with potential collaborators or enter into licensing agreements. And eventually, if you get acquired, the patent portfolio is a significant source of company valuation. The last point is a startup valuation can be increased simply by filing an application. The typical process of filing a utility non-provisional application will cost around between $6,000 to $10,000. Now, after you file that and you go to an investor, you can say, hey, this is an IP asset and it's worth at least $100,000 to $200,000. Most investors will not bat an eye. So if you use an investor's approach to investing in companies where they expect a 10x return, a patent easily fits into a 10x return per the valuation methodology that we just discussed. So in summary, the patents offer startup many significant benefits, and then the downside might be some costs and some time. However, if you use the proper software to document your invention, such as the Power Patent solution, and then you take the output of that and send it to a law firm for review, you should be able to trim your costs down to well below the $10,000 pricing that we see in the market today. So I hope that you will consider patents as part of your corporate strategy. So now that we have established the importance of patents, we need to know common pitfalls and how to avoid them. So first of all, you should avoid filing the application too late. So an example is, let's say you came up with an idea and then you start talking to your contractors and your vendors to make the product, and then you also talk to investors. Now, in general, investors do not sign confidentiality agreements. So if you talk to them, that's basically a public disclosure. And and let's say if you put your ideas on your website, that is a type of public disclosure that can come back and be used as prior art against your own application if you file too late. For example, if you file this outside of the 1 year grace period in the United States. In international countries, the mere fact that you have your, let's say, website or your Kickstarter description of your patent, of your invention before you file a patent, that will in fact be a bar to your own patenting activity. So file as soon as you can. The next pitfall is poor documentation. So the importance, a patent application is only as good as the details behind it. So in computer language, we call that GIGO, garbage in, garbage out. You need to have high quality disclosure of how your system works, preferably at least 30 to 50 pages of description and at least 10 to 20 diagrams, right? So what's the advantage of the high quality documentation is that number one, your first application tends to be the fundamental patent application that you will need to keep alive and tweak it over over its life, the 20-year life, to track, let's say, changes in your competitors' behavior, and so the more details you put into the application, the more range you have to adjust your the claims in your continuation application. And so how do we handle that? You can do that if you're experienced, but if you've never done an application, we would recommend that you use software that can guide you through the process of documenting your invention in a structured manner. So consider software such as Power Patent, where it's a proven way to generate high quality patent application. And it acts as a co-pilot to guide you in putting in the proper structure, so that once you've done that, then you can send this to your lawyer, and then they can finalize it and file it for you at a significant discount. And so the use of Power Patent can save you money. So another pitfall is you neglect international protection. Now, we recommend that if you consider international protection very carefully, because the cost can mount quickly. So what you should do is analyze what products you have, where is it likely to be commercialized. So let's say if it's going to be a product that's used exclusively in Canada, I would do the US and Canadian patents. Or if you decide that your product's going to be sold in Japan, do those specific countries. because each of those countries, the cost can mount. One cheap way to handle this is use the PCT, or Patent Cooperation Treaty process, where you can defer the decision to go international by up to 30 months from the very first priority date that you claim. So let's say you file a provisional this year, and you would have, and if you file a PCT within the 1 year period of international filing, you can have delay your international filing deadline by up to 30 months from the date of your provisional application. So that's an example. And then there's another common pitfall is you ignore the freedom to operate analysis. Oftentimes people come up with a product, but then they don't search on how on the competitor's IP to see if there's any risk. And if you're aware of the IP, you can possibly design your products around a competitor's patent that blocks you from implementing that particular feature. But if you know this in advance, you can do that, and it'll be a lot less expensive. So the key takeaway for you here is to be aware and take proactive measures to protect your own IP as well as to respect other people's IP. So next, let's talk about aligning your intellectual property with different company growth stages. Such alignment is crucial for maximizing value and protecting your IP assets. And we will discuss a general overview of how to approach IP at each stage of your startup. The first stage is you're in the seed, early stage, or pre-series A stage. What you should do is focus on your core innovation, identify and protect the core technologies or innovations critical to your value proposition. You should build a foundation, lay the groundwork for a robust IP strategy by filing provisional patent applications and securing essential trademarks. You can also leverage your trade secrets. Prioritize confidentiality to protect valuable trade secrets, such as how you train your AI, such as your potential customer list, such as your plans to enter the market. Those are trade secrets that can be protected with the proper measures. Next, we'll talk about Series A. At the Series A, where you have more resources, you should strengthen your portfolio. Develop a comprehensive IP portfolio by converting the provisional patent applications into non-provisional ones. Expand the patent filing to cover key aspects of the business. You should expand on your trademark, register trademark for products, services, and brand elements. Align the trademarks with the company's growing market presence. You should also start evaluating your freedom to operate by assessing potential infringement risks and ensure that your products are designed to have freedom to operate in your target markets. Next, we'll talk about what you can do at Series B, fundraising. You need to start thinking about global IP strategy. Expand IP protection internationally and considering the markets where the company plans to grow, and you start filing additional patent applications in these key jurisdictions. We recommend you do this only at Series B because of the cost of international patenting. You also might want to look at strategic licensing. So often a startup will pivot, and some of the initial IP assets may be available for licensing because you're not using it anymore. So you should explore licensing opportunities for non-core technologies to generate revenue for the company. You should also monitor your competitors. Implement a robust monitoring system to track and respond for potential infringement so that you can protect your exclusivity and protect your go-to-market strategy. Then at Series C, we should start looking at IP commercialization. You can optimize the commercial value through strategic partnerships, through joint ventures, or licensing agreement. You also look at defensive strategies. You strengthen, you increase your portfolio because now you're at a stage where you might be attracting eyeballs from bigger companies, from your existing competitors who might want to look for ways to push you out of the market because you're becoming now a serious threat. So by building a big patent portfolio, you have a chance to do cross-licensing. Number one. Number two, if you've done your freedom to operate analysis, you should be in a good place to discuss why you don't have an issue with your competitor's IP portfolio. To do this, you also need to do IP audits, and you should periodically conduct IP audits to assess and enhance the overall value of the IP portfolio. Now we're going to talk about Series D and pre-IPO factors. At such a late stage, you need to do IP due diligence more thoroughly. And so having a thorough IP due diligence process, you are now prepared for potential mergers, acquisition, or even an initial public offering. And so you need now to check for legal compliance with IP laws and regulations to mitigate risks during the IPO process. You should also conduct IP valuation, and that's where you can evaluate the company's IP portfolio and articulate its value to investors, particularly in your SEC filing documents. Eventually you will reach the post-IPO, or you're now a publicly traded company. The process you should take there is defensive portfolio management, and this is done by strengthening the defensive aspects of the IP portfolio, particularly in the face of increased visibility and potential litigation risks. You should also encourage your inventors and your developers to do continuous innovation, and this is done by maintaining a proactive approach to innovation and patent filings to stay ahead of competitors. You should also look at your brand protection both domestically and internationally. Your enhanced efforts to protect and enforce the trademark needs to be increased as the brand becomes more of a significant market force. Throughout these stages, it's essentially for all companies to align their IP strategy with the business goals, regularly review and update your patent portfolio, and seek legal counsel to navigate the complexity of the IP system. With this, you will be top of the space with respect to the coordination between your IP strategy and the business strategy execution. The timing of patent filing is a critical consideration in the protection of intellectual property, and utilizing software tools like PowerPatent can enhance both the speed and the quality of the patent preparation process, particularly in the context of software-related inventions. So what you want to do is to have an early filing priority date. In many jurisdictions, patent rights are granted based on the first-to-file principle. Filing early helps establish priority over potential competitors' filings. You should consider software such as PowerPatent to expedite the initial stages of drafting and filing the application, ensuring a timely submission of the patent application. Let's talk about the differences between provisional and non-provisional applications. So filing a provisional application can provide a cost-effective way to secure an early filing date. However, the quality of the provisional application is important. As we stated earlier, in computer science, there's a term called GIGO, garbage in, garbage out. So if you file a one-page provisional application, you are likely not to have gained much. However, if you provide an in-depth utility, a non-provisional like quality, then that provisional application can be powerful. So if you use software such as PowerPatent, they have a structured approach to documenting the invention, so that the provisional application can be drafted in a way that's very, with a quality that is similar to that of a non-provisional. So the details are provided in the application, and that can be very powerful when you convert from the provisional into a non-provisional application in a year's time. So you may want to consider accelerated examination options. So if your inventors are in the U.S. Are older than 65, you may qualify for accelerated examination for free. Otherwise, you can just simply pay a fee. I think they're not cheap, but certainly it's well worth the money if your invention is worth billions, right? So when you get accelerated examination, you get ahead of the examination queue, and that can lead to a faster issuance of the patent. The use of the software can reduce errors and enhance quality. Most of the software like Power Patent or its competition, they employed advanced algorithms and databases to assist the inventors and the lawyers in identifying the detailed disclosure in the case and also the way in the terminologies that may provide obstacle during the examination process. So these automated features help reduce errors and improve the overall quality of the application, and because applications, at least the first draft of it, can be generated in 5-10 minutes, you can get a very high quality first draft very quickly, and then from then you can supplement the first draft with additional insights from the inventor. So the key takeaway here is that the timing and the type of patent filing they require careful consideration. Software patenting involves obtaining legal protection for innovative software-related inventions. A software patent grants the holder exclusive rights to use, make, sell, or license the patented software invention for a specified period. In the US, it's 20 years from filing. We will now discuss the historical context and evolution of software patenting. So, in the early days, in the early years of computing, software was generally protected under copyright and not under the patent system, as it was considered more akin to mathematical algorithms, which were not patent eligible. Now that changed in 1981 in the Diamond v. Diehr case, where the U.S. Supreme Court established that software implementing a mathematical formula could be patentable if it produced a practical application. This decision marked a turning point for software patent eligibility. In states, in 1998 and in 2010, the court decided the State Street case and the Bilski case. In State Street Bank and Trust Company versus Signature Financial Group, and later the Bilski versus Kapos case, the courts clarified the patentability of the business methods, including software. So as long as they can meet specific criteria, such as being tied to a particular machine or transforming an article, they are patentable. However, in the case of Alice versus CLS Bank in 2014, the Supreme Court imposed stricter guidelines, stating that the abstract ideas implemented on a generic computer were not eligible for patent protection. This decision has significantly impacted the patentability of certain software inventions. However, there are still ways to protect software-related inventions if you can establish that it improves machine performance or transform the utility of the result. So more recently, the USPTO has provided guideline to determine eligibility of software patent applications. So what are the key challenges for doing a software patent? So first of all, you have to establish subject matter eligibility. Determining what constitutes patent eligible subject matter for software invention, especially in the context of abstract ideas, remains a challenge. The distinction between abstract ideas and concrete practical applications can be subjective, and however, with the proper legal assistance, you can make a case for software patenting of your software invention. So another challenge in software patenting is the rapid technological changes. The fast-paced nature of the software industry makes it challenging for the patent system to keep up with evolving technologies. This leads to concerns about the relevance and adequacy of patent protection. However, this can be solved with a skilled practitioner who can use the accelerated examination program, and also in claiming, so that you minimize the number of trips back and forth to the patent office. So the takeaway here is that to enhance the chances of obtaining a software patent application, you need to emphasize the specificity of the software invention and its practical applications, rather than the abstract concepts of doing something using a computer. The other thing to focus on is how your invention accelerates computer performance. So that's a way to get out of this abstract, the Alice rejection. So the other thing is to file more applications, given that the enforcement of software has been spotty. Roughly, I think more than half of the patent litigations involving software patent has turned out in a negative. So what you should do is to file higher quality patent applications and do more of that. And this is easy to do given continuous innovation techniques, right? Given the evolving legal landscape and rapid technological changes, what you do is you just file more cases, and this can be done cost effectively using software such as Power Patent, which can create a first draft in about 10-15 minutes. And then, of course, a professional can then come in and clean it up. So because of the legal challenges involving software patents, you need to engage with IP attorneys who specialize in software patenting to navigate the complexities of software patent space. And so in short, software patenting is a dynamic and evolving area requiring vigilance, adaptability, and a nuanced understanding of legal and technological landscapes. Next, we will talk about patent search. In general, we recommend that you do a patent search before you start the process of patenting, because it's an expensive process. So it makes sense for you to at least do a sanity search to verify that your invention is novel. So part of the difficulty in doing the patent search is how do you search for novel aspects? Initially, you're going to have to come up with an angle on, let's say, what are the minimum features of your invention that you think to be novel. And so what you would do is then go to a search engine, such as the engines available at the US Patent Trademark Office or at the European patent offices. You can also use Google Patent Search, although there are some people who fear that providing that input into a public search engine means exposing the idea to Google, for example. So in general, you can use, there's a number of search engines that you can use for free. So that's one option. The other option is, if you want, is you can always hire a firm to do a search for you. So in a professional search report, they will normally pinpoint, let's say if you claim novelty, the novelty is they include A, B, C, and D. The search will then pinpoint, where in the references would they show A and B and C and D, and so they may combine 2 or 3 references to show all of the novel elements of your inventions, or it may, and that's called obviousness. The invention is obvious, or they can show everything into one single reference, and that's the novelty. You lack novelty if everything exists in one reference. So in general, we recommend that you, if you're writing a provisional application, just do a sanity search, and then you can use that information to train, to write your application and focus on what is the novelty and how it differentiates from the prior art. And in cases where it's a make or break of the company, and when you think that the patent is so important, then it makes sense to utilize a professional search firm who can search international documents. They can search non-patent document as well. And so that's the way we recommend it is for most inventions, you just do a sanity check on your own. For important applications, you should consider use a professional search firm. Now let's talk about key considerations in software patenting. First, subject matter eligibility is very important. So the eligibility of software patent often hinges on avoiding the characterization of the invention as an abstract idea. As stated earlier in the Alice case, the Supreme Court established a two-part test. A, is a claim directed at an abstract idea? And B, does a claim include an inventive concept that transforms the abstract idea into something significantly more than just the abstract idea? So your strategy is to clearly articulate how the software solves a practical problem or improves a technological process. The application should emphasize specific and tangible applications, as well as how it improves system performance or system output. So for example, if your software improves compression by a certain percentage, then that should be brought out as part of the specific and tangible application. How do you circumvent the abstract rejection? As discussed earlier, you should highlight any technological improvements or innovations achieved by the software. Demonstrating how the software addresses technical challenges or enhances computer functionality strengthens the case for patent eligibility. That's why you should have a standard paragraph in your application describing how it improves processing speed, processing performance of the computer, or how the output, the result is improved. You should provide a detailed description and a comprehensive description in the patent application that clearly outlines the technical components, the processes, the functions involved. And if you have this in the application, it minimizes the risk of the abstract characterization. Of course, avoiding the abstract rejection is only part of the work. You still need to show that the invention is novel and non-obvious. So overcoming rejections based on anticipation or obviousness can be challenging due to the vast amount of prior art in the software domain. So how do you handle this? One way to do that is a prior art search to identify and address potential challenges. This involves not just searching existing patents, but also technical literature, open source projects such as those at GitHub, and other publicly available information. Additionally, your claims should be very specific. You should craft claims using precise languages to clearly distinguish the software invention from the prior art. The claim should highlight unique features, algorithms, or methods that sets the invention apart. You should also discuss in the description specific and substantial utility. Clearly define the specific utility or practical application of the software. Show how it provides tangible benefits or solves real-world problems. Avoid vague or overly broad utility claims. You can also provide a use case scenario or example in the patent application that demonstrates how the software is applied in practical settings. This strengthens the argument for utility. You should ensure that the software is described in a manner that enables a person skilled in the art to understand and reproduce its functionality. Clarity and operability contributes to demonstrating substantial utility. You may want to consider putting in a section of the code or the data structure that is important in your particular invention. So, in summary, successfully obtaining a software patent involves presenting the invention in a way that aligns with the patent eligibility criteria. emphasizing concrete applications, technological improvements, and specific utility while navigating the evolving legal landscape contributes to building a robust and defensible software patent portfolio. Regular collaboration with legal experts with software knowledge ensures strategic and informed decision-making throughout the patenting process. Next, we will discuss the process of obtaining a patent. So, as an overview, the process begins with the idea, the conception of the idea by the inventors, through filing for the patent protection, and then you go through examination, and then eventually the patent is granted. So what do we need for filing the patent application? After you've ideated the concept, then you need to generate documentations about how the invention works. So the documentation can be a number of forms, such as a Word document or a series of drawings, and the combination of which provide a very detailed description of how the invention operates. After we have that, then we can discuss what type of patent applications to file. You can have provisional patent application, you can have non-provisionals, or you can directly file international applications. So a provisional is a temporary application that lasts within a year that must be converted to a non-provisional. The non-provisional application is the one that's actually examined, and that's when you will get some pushback from examiners as to your novelty or your obviousness. The PCT application is for companies that are well-funded, that is interested in seeking international coverage. And the PCT application can be done either upfront or can be done within 12 months of the first application file. And if you do that within the 12-month basis, you can claim the priority date, stretching back to that 1 year. And so PCT is a useful mechanism to defer some of the international expenses because it delays the international filing date up to 30 months from the first filing date. So you can wait to file internationally up to 30 months and still can get the priority date of your first file application. If you have questions, just text me on that. So once you file a non-provisional patent application, it goes into a queue where other applications have gone into, and eventually you'll exit the queue for examination. That transit time is approximately 18 months to about 2 years. And the examiners will pick up your case, and generally what they'll do is they're going to do a patent search, and they're going to try to push back on you if they find relevant prior art that indicates either the identical invention has been done already, or if they can point to 2 or 3 other patents in combination make up your invention, and they'll say that that invention is obvious in light of these 2 or 3 prior patents. So then you need to argue with the examiner as to why the combination of references may not be correct. And if you're successful, the examiner will send you a notice of allowance, and then upon paying the filing fee, it becomes a patent. So once you have a patent, then you have exclusivity for that concept for the life of the patent, which is around, in the US, 20 years from the filing date. Every 4 years, there is a post-grant process where you have to pay a maintenance fee, and if you don't pay the maintenance fee, then the patent lapses. So in general, because this is a complicated process, we recommend that you use the services of a lawyer, or if you want to save money, use software that guides you through the process of writing the application so that you can write a document as completely as possible on your own writing time. And then you can take that document to a professional, such as a lawyer, and seek professional assistance in filing it. We think that that approach is the best way to save money because you know the domain of your technology and you can utilize a software that guides you into this process. And once you have all the documentation in place, the lawyer can use her expertise to refine the claims and to improve the quality of the application to maximize its chances of success. So we recommend that you, the first time you've done it, then use some sort of a software to document your application. And then you take that to a professional and request a discount. And this process will save you money, save you time, and improve the overall quality, because you are now collaborating with the lawyer to improve the quality of your application. After obtaining a medical device patent, there are several post-grant activities that you may need to undertake to maximize the value and protection of your intellectual property. Here are a few post-grant activities for your patents. First, maintenance fees. Mark this on your calendar to regularly pay maintenance fees every 4 years to keep the medical device patent enforced in the U.S. Internationally, annuities may be due on an annual basis. And so the failure to pay these fees can result in patent expiration. The other activities include surveilling the market. So you need to monitor the market for potential infringement. Your salespeople can keep a vigilant eye on competitors to see if they are using similar technology or products that your patent covers. You need to stay informed about the activities of the competitors, and this includes tracking their new product releases, their patent filings, and any legal actions relating to patents. You should continuously assess the overall patent portfolio and consider filing additional patents for improvements, new features, or related technologies that may arise in the development of new versions of your medical device. You should also explore licensing activities. The licensing agreements can generate revenue through royalties and expand the reach of your innovation. You should consider expanding the geographical coverage of your patent protection by filing for patents in the key jurisdictions. This is important for global market penetration. Of course, you should be keeping an eye on technology. Stay abreast of technological advancements in your field. This awareness can identify opportunities for further innovations and potential adjustments to your patent strategy. So by actively managing the post-grant phase, patent holders can maximize the patent investment and leverage the patents for business growth, collaborations, as well as for maintaining a competitive advantage in the space. Regular assessments and strategic decision making are crucial in navigating the evolving landscape of medical device patents. We hope this will give you thoughts on how to implement your patent strategy. Thank you for joining our intellectual property education series. We hope that this journey has empowered you with the knowledge to navigate the world of patents, trademarks, trade secrets, and copyrights. Stay inspired, protect your innovations, and continue to explore the boundless possibilities of your inventive mind through the intellectual property system. Subscribe for more insights, and until next time, innovate boldly.